may be begun. Mr. Judge, report.
Mr. Marshall, please open the floor.
Oyez. Down the Supreme Court, page 10, down the session. Courts presenting cause that can be there, give it to them to watch the law. Thank you.
Good morning, everyone. Welcome to the Supreme Court. We have three matters that are related to each other today. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. Counsel, you ready to proceed? Please take the podium, identify yourself for the record, and let me know how much time, if any, you wish to reserve for rebuttal.
May it please the court, my name is Daniel Casagrande. I represent the plaintiffs' appellants, Reserve Realty LLC, and Theodore Haddad, Senior Executor of the estate of Jeanette Haddad. I would like to reserve 7 minutes, Your Honor.
You have your 7 whenever you're ready, counsel.
Thank you. This case presents the opportunity for this court to reaffirm the well-established principle in Connecticut that the courts will not interfere with commercial contracts entered into by sophisticated parties after extensive negotiations and with the benefit of the advice of counsel. That's the Talmadge case, the Schwartz case, and the Holly Hills case. Parties are free to agree on whatever terms they choose based on calculated considerations, and they are free to assume the assumption of known and unknown hazards and risks. That's what the parties did here. When the language is definitive and ambiguous, as the appellate court found it was here, courts will not rip up bargains unwisely made. But unfortunately, it's our position that that is exactly what the appellate court did here. The first issue is whether the duration term of the listing agreements complies with subsection C of 20-325A, which states that commercial listing agreements must state the date of the the duration of the authorization. Here, the terms, as the appellate court found, are clear. They're definitive. The term begins after BLT or WINDEMERE acquired Title 2, Parcel 13 and 15, and shall be for a term of 10 years beginning with the date of the first sale or lease of the whole parcel or any individual unit thereof. Now, the appellate court, invoking Talmadge, said that the agreements are definitive and unambiguous in setting forth the durations. They distinguish between the durations of the buyer's agreement and the listing agreement. I'll rely on my brief for that, and said that they were intended, the two provisions were intended to apply to two different transactions. It went on to reverse the trial court's ruling that the agreements are invalid because they did not contain an expiration date. The trial court had relied on a regulation that dealt with residential agreements. The appellate court said, no, that was incorrect. You had to rely on Regulation 20-328-6AD, which says only that commercial listing agreements must set forth the duration of the authorization. So it reversed the trial court's holding that the agreements were invalid because they did not set forth an expiration date. But here's where we think the appellate court went wrong. It went on to say that the agreements were indefinite because they had no, quote, ultimate ceiling on the ultimate of time that they would last. And at the time the parties entered into the agreement, they didn't know when the trigger date of the first sale or lease would be. That's true. We think that's an error of law. The standard, obviously, under location realty for review of agreements for compliance with the statutory requirements is plenary, and under subsection C of the statute, it is a more flexible review than under.
Well, counsel, can I ask you about the first part over here?
Yes, Your Honor.
This way.
Oh, sorry, Your Honor.
That's difficult. I know. The first part is that the agreement, the buyer's sort of portion. What definition of duration would you use? Because it seems like the appellate court used the definition that it's a time period capable of being measured. And by your own admission, that time period could last forever. At the time they entered into that contract, it could never come to fruition. So what definition, if we're looking at tied to the statute, what definition would you use for duration that would fit?
The response is that I believe the agreements do set forth a measurable duration. They have a specific trigger date for starting them, the date of the first sale or lease, and 10 years after that. So they have a fixed commencement date, and they have a fixed termination date. And again, the parties knew exactly what Your Honor is saying. The parties knew that when they signed the agreements, and they willingly signed them knowing, again, assuming unknown hazards or risks, which they were free to do as a matter of Talmadge and Scalzo. And again,
so you don't have any objection to, or you don't have a different definition than the one the appellate court used for defining duration?
the appellate court relied on dictionary definitions, and the appellate court also said, we acknowledge that the duration is capable of being measured in some form. They just said, well, because it doesn't include an ultimate ceiling date, which I find to be logically inconsistent, because how could they on the one hand say you don't need to have an expiration date, but on the other hand it's defective because you don't have an ultimate ceiling? I find that inherently inconsistent. And the parties knowingly agreed to this. The defendants in their brief, to that point, Your Honor, they say, well, notwithstanding the trial court's findings that these agreements were extensively negotiated over time, a period of several months. In fact, there were 14 drafts that were circulated between July and the September meeting in 2003. They say, well, we were blindsided. We came into this meeting and we were given a new agreement we hadn't seen before. What I'd like to do is refer the court to Defendant's Exhibit 148, which was Exhibit 108B of the trial court.
Well, whether or not these were carefully negotiated over here, we should have little lights like, you know.
Sorry, Your Honor, it's hard
No,
to see.
No, I understand. You know, they were carefully negotiated, sophisticated parties and so forth. That still leaves open the question of what duration means, right? I mean, as you said, it's a legal question under the statute. So, I mean, it's really about, it's clearly a fixed and known amount of time ex post, afterward, looking backward, you know exactly when it started. The minute you know when it starts, when the triggering event occurs, you know exactly the time. So I guess the question is whether duration has to be determinable prospectively, ex ante, right? I mean, if you know, and so can you comment on that in light of the purposes of the statutory requirement of duration? Is it something that everybody has to know when they put the ink on the deal, or is it something that it's fine, it satisfies the purpose of the statute as long as it's knowable once this triggering event occurs?
I would say the latter, Your Honor. I think.
But why is that? But what about what's the purpose of this statutory requirement that supports your construction?
The purpose of the statutory requirement is to guide the parties in their dealings going forward so they know what their risks are in going forward. Here, the undisputed evidence was that the parties knew when they signed the agreements that the trigger date might not occur for several years. The Keeners acknowledged that in their testimony over and over again, and yet they held their nose because they didn't want to have the Haddads as brokers, and they didn't like the duration term either, but they signed it. And this is why I was referring to 108B, Your Honor.
So the essential fact from your point of view is that the parties, right when they signed it, knew that they could, there was no question or doubt whatsoever about the duration. The only issue was when it was when it started,
Yes.
but there was no question about when it would end after it started.
Yes, that's my position. And and again, I'm sorry, Your Honor.
No, please finish.
I would cite the court to, the appellee's cite to 20-320C, which is a statute that says any listing agreement that has a fixed termination date and also is, has a provision that it automatically continues is void. Okay. What does that tell us? It tells, first of all, these agreements do not have a fixed termination date. That's clear. And they don't have an automatic continuation date. So number one, the statute is inapplicable. But more importantly, what it shows is that when the legislature wanted to put in a provision in the statute saying you have to have a fixed expiration date, they knew how to do it. They didn't do it in subsection C. To me, that is a compelling inference that the legislature knew what they were doing when they're saying duration. And again, these are not residential agreements. I certainly understand the appellate court's concern about open-ended listing agreements when you're dealing with residential customers, because the legislature in passing the statutes basically says that consumers are not generally as savvy as commercial parties. But here,
Well, so that's where my question comes in is, you know, you answered Justice Ecker's question about what the purpose of the durational requirement is as guiding the parties to the contract. But my question is it limited to that? Is there a public policy that essentially exclusivity agreements are maybe frowned upon, and maybe there's other folks that, like other brokers or the ultimate consumers, that this statute is in place and this requirement is in place, so that I take your argument, certainly, that the appellate court decision seems to add something like a fixed date to, but often we add things like reasonableness to statutes that don't, especially when it concerns time, you know, reasonable amount of time, things like in the UCC. So what I'm getting at is it fair, or why isn't it fair to say, well, then you can't craft a provision that could tie this up forever so that other brokers don't have a shot at it, consumers ultimately pay the cost of?
First of all, the appellate court said we don't even have to get into policy and custom because we deem the language to be definitive. But then they said, well, as a practical matter, there's some policy issues.
Mm-hmm.
Those policy issues, we believe, are inapposite. They said that the appellate court worried that a broker might do no work and then claim commissions based on another person's labor. That's not the case here. The trial court found expressly that Jeanette Haddad.
It may not be the case here, but
Yeah.
if the question is how do we construe duration, does it have to have some sort of a fixed date, or can you contract around that somehow such that you know, it could be tied up forever?
Yeah.
Go ahead. I think you know where I'm going.
Yes, Your
Yeah.
Honor. The answer is, because these are commercial agreements, I believe the answer is no. It doesn't have to have a fixed date. They said what they meant and knew what they said and meant what they said. And I would also cite to the case law that is in our reply brief on the modern view of definitiveness of contractual terms. The ancient view, which the Harris case in 1922 espoused, was that, well, you got to have some date in there. We just have to put a definitive date, and we, the courts, are going to do that. That was 1922. 1994, the legislature added what's now subsection D and said the parties are free to agree on whatever duration they want. So the other, and again, as breaking it down as the parcel 13 and parcel 15, the evils of open-ended listing agreements are just not present here, because there was a start date, the first lease in 2013, and there is an end date. So applying the modern view of definitiveness, it's our position that the party's conduct after the contract rendered the contract definitive. And again, the modern view is that courts are loath to rip up these commercial agreements. Even in the context of 2325A, the appellate court's decision in Goldblatt says as long as the statute is substantially complied with, the parties are free to agree on whatever terms they wish. And that's what they did. Just very quickly to go back to Exhibit 108B. That was a draft of the listing agreement that Carl Keener Sr., who was the agent for the defendants, was sending back and forth to Ted Haddad Jr. in the weeks before the meeting. And in that draft, and I'm specifically citing Defendant's Appendix 144, you'll see that paragraph 6, the term agreement, Mr. Keener had crossed that paragraph out and he said, I want these agreements to start on the date they're signed. August, or at that point, 2003. What did Mr. Haddad Jr. do? He said no. And he came to the meeting with the original provision that the agreements start on the date of the first lease. And he brought it to the meeting. And I showed Paul Keener this exhibit at the meeting. I'm referring to Reply Appendix pages 88 to 90. And I said to him, so therefore your father was negotiating this specific term back and forth. It was not an oversight. It wasn't overlooked. It was a specific focus of the negotiations. And you walked into that meeting and you knew or should have known that Ted Haddad put the provision back in there. And I said, you could have, Mr. Keener, called your dad and say, hey, he put the 10-year provision back in. It's too open-ended. We don't want it. He said, yes, I could have said that. You could have walked away from the meeting because you had time. You didn't have to do it that way. But you didn't do it, and these are his words. If you had any objections to any of the language in these agreements on September 10th, you could easily have said, look, we got another 37 days. Let's not rush into this. Let's go back. Let's regroup. Let's look at what you presented to us today, and we'll meet you next week, right? You could have said that. Yes, but you didn't, right? Correct. And the reason is because you wanted to get these listing agreements signed so you could go ahead and do what you need to do to close on these very favorable transactions. Correct? Answer, correct. They focused on it.
Can I ask you a question about the other, just so we don't run out of time?
Yes, Your Honor.
I mean, somebody else may want to revisit the first issue. The second issue wasn't decided by the appellate court.
The subsection D issue?
No, the personal
personal services issue?
Personal services issue. And just a question on that. You started your presentation today by invoking the idea that, sophisticated parties are bound by their contracts. And I wanted to know how that theory fits with the second issue, which is to say that Jeanette Haddad, which I think everybody agrees she was a successful business person, very successful in the area, sophisticated business person, and she or her son, whoever, did the deal, they signed the listing agreement in her name personally, right? Which has great significance in Connecticut law, most law, either you sign for the LLC or you don't, you sign for the company or you don't as its president or something, but this was a personal, this was her name. And so what I'm wondering about that, for my own point of view, is just doesn't concern me so much who was doing the work or the commission work for her, maybe. Mr. Rooney may have a different view, but after she died, how would she be entitled to her estate, anyone else be entitled to any commissions after she dies for earnings after she dies, I should say, for earnings made,
that accrued after she died. Yeah.
Exactly. How can that be?
First of all, can I take the first part first, Your Honor?
Anything.
The fact that she signed it does not mean that she had no authority to delegate. Even under the statutes, I don't have the statute in front of me, a broker may sign an agreement.
That's fine. I'm talking about after she died.
You're talking about after she died. Here's the answer. The Supreme Court in Covino versus Pfeiffer, 162 at 215 to 217, which was cited in the Levy-Miller case and in the Dowling Condon case, which Judge Bedevegna decided in 2009 said, if during the term of the agreement, the owner, the exclusive right to sell agreement, the owner breaches by negotiating with another party without the consent of the broker, the fact that that agreement was not signed until after the expiration of the listing agreement is immaterial. The only issue is whether during the term of the agreement, the broker exercised reasonable efforts to market the parcels, which the trial court explicitly found here, and does the evidence show that defendants breach? How did the defendants breach here? They wrongfully prevented the brokers from marketing the Abbey Woods, starting in 2010 all the way through 2013. The appellate court said they gave the brokers no
But
opportunity to
after
market.
2013, are there any transactions at issue? I may be asking a meaningless question. Are there any transactions or commissions at issue that were earned after her death in February 2013? Or are you only looking for commissions earned prior to her death?
My argument is that her right to commissions on the Abbey Woods leases, which did not begin until after her death, vested before her death, because before her death, the defendants wrongfully prevented her and her agents from performing the agreements. That's Covino. That's Levy Miller.
Without any evidence that she would have or could have closed deals on those? I mean, prior to her death, the idea is that they withheld information about Abbey Woods for a period of years.
Yeah, that's not the issue.
But they were trying to market those units.
They were trying to market those units when they were being presented by the Keeners as a sale of the entire parcel. Remember, in 2010, the Keeners said, "Oh, we got a bad recession here. We're going to switch gears. We're going to turn this into a rental complex."
Doesn't there have to be proof at least that, but for the wrongful conduct, she would have, or her agents would have completed deals?
No, because under the doctrine of wrongful prevention, and this is the Kastner case cited in Covino and in Dow and Conner, that's the seminal case on wrongful prevention. If the party breaches by wrongfully preventing the other party from performing, the issue of whether the other party performed or didn't perform adequately is irrelevant.
And I'll end my questioning on this, and but no court has yet ruled on this particular issue. I understand on the personal services issue, generally, the trial court did rule, but there's no court yet in this case that's ruled on the point you're making right now in terms of date of death issues.
No court has ruled on it.
Right.
And this is where I think the trial court was mistaken. The trial court, I think, was frankly misled by the notion that under an exclusive right to sell, you're only entitled to a commission if you procure a party. And that's throughout the trial court's decision. The appellate court said that's not the case, but they still focused on the fact that she hadn't procured someone during her lifetime. But the reality is, and I'm almost out of time, the reality is the appellate court, they say, well, yeah, the brokers never gave, the Keeners never gave the brokers the opportunity, but somehow they found evidence that the trial court never found, saying, well, the brokers' efforts after 2007 left much to be desired. Nowhere in the trial court's decision is that. The brokers, after they learned of the Abbey Woods complex, did nothing to market the parcels. How could they have done anything to market the parcels when Ted Haddad Jr. found out about the complex and goes to Carl Keener in March of 2013 and says, will you honor the listing agreements by allowing Reserve to continue to serve as broker? Keener said no. And the reason he said no, and this is what their intent was from the beginning, they never intended to use these brokers. They always intended to use third-party employees as their agents. That's a breach. That's wrongful prevention. And when you have wrongful prevention, Williston and Kastner are clear. It excuses not only performance by the non-breaching party, but even the offer of performance. I see my time is up. Thank you, Your Honor.
Thank you, counsel. Your decision.
Yeah.
may proceed.
Thank you, Your Honor. May it please the court, Christopher Rooney on behalf of the defendants who are VLT Reserve LLC and Windermere Reserve LLC. I'd like to begin with the first issue and really try to go through in a disciplined way the approach of the appellate court in analyzing the statutory language. And the court begins with, as they should, Connecticut General Statute 1-2Z, which we all call the plain meaning statute. And it searched for the meaning of the duration of authorization language from subsection C. And it used classic approach. It determined that the language itself could be understood based on its plain meaning. Relying on a dictionary definitions, it concluded that it means an amount of time that is capable of being measured. And as Justice Mullen points out, there really hasn't been any protestation about the approach, at least thus far, by the appellate court on interpreting the language. I don't hear from counsel any complaint. Justice Mullen offered him a chance to give a different definition, and he didn't.
Well, even before you go too far, that definition has the definition that the appellate court used has interesting language in it. I mean, one could say that it doesn't specifically say that the time period has to be identified for duration.
Yeah, I think there may be some blurring of lines here. I'm not contending that you have to give a specific date under Section C, and I don't think that that was the contention of the appellate court. I think it is that you need to be able to determine what the starting date is with definity. And, you know, that
time of the signing of the contract?
I believe at the time of the
Why?
signing. Well, because what we admire or what we seek in contracts is certainty of, and this is to the question somebody put, the policy behind this is so not only the parties to the contract understand what the obligations are, but there are third parties out there who are being excluded, who need to know when they can come in and offer a prospective purchaser, and they're precluded as long as that contract is in force. So
They have a right to see the contract between the two parties?
No, but
How do they
these
rely on that then?
these are generally published, and parties understand when something's under contract. You can talk to an owner, for example, and say, is this property being handled by a broker? I mean, due diligence by any broker within the industry will tell you whether or not it's under contract. And there's a case called Bezo. It's a great illustration of somebody who got caught in that trap because they didn't understand that there was an exclusive agreement out there. And so it's a buyer beware situation. Other brokers have to make sure that it's not under contract. So these provisions exist for the benefit not only of the regulated public, which are the brokers, but of the people for whose benefit they were adopted.
But if that's the policy, you know, you'd think that the legislature would have included some of the adjectives that the appellate court needed to add to the statute, fixed, or that is in one of the other statutes, such as, you know, a specific end date. It's just a little hard to say that certainly there is a durational, a measurable duration. It just may not be definite right now. And you're saying that it has to be definite. Where does that come from?
Well, it has to be capable of being determined by the parties.
When? You're saying
At the time of contract, of course, because as soon as you start to perform, as soon as
be nice, but I don't see that in the statute. You do?
it's not in the statute, Your Honor. I'm now relying on basic contract. The case of Harrison versus McPherson cited by the appellate court is the common law approach, which basically says, yes, you do need a definite date in here. That's the holding of this
As
court.
between the parties to the contract, that may be true. That, you know, maybe somebody's going to say, look, we have a dispute as to when this began. But your argument is that this protects other people.
It does.
And to do that, it needs to have a start date that is measurable by them.
It does.
Doesn't say that. And the parties seem to be okay with executing contracts that don't have it.
Well, generally, we believe that the legislature is aware of the rulings of this court and essentially adopts statutes in conformity with the holdings of the court. Harris versus McPherson is good law to this date because it is a general law on the issue of exclusive dealings arrangements for brokers. And the court says flatly, exclusive sales is given to the broker for a definite time. That's your court speaking long ago, but
Sounds
clearly
like you don't need the statute then.
you really don't. But I think the statute is really adopting the same approach the court had for years and embodied it in the statute. It's interesting that the commissioner in adopting regulations uses the same language over again in the regulations. So clearly the commissioner who's charged with doing the regulations feels that it's sufficiently clear. The appellate court, the 3-judge panel unanimously agreed that that term is sufficiently clear, at least based on these
The statute
definitions.
doesn't say definite duration.
It
right?
does not.
Okay.
No, it does not.
And it's definite once you know the trigger date. So
Correct.
it doesn't really answer whether it's definite but not known. It'd be like if I said to my daughter, look, I'll support any children that you have for the duration of their lives. And she didn't yet have any children. I mean, that's a duration. It's measured by their life. And we know when it starts and we know when it ends. Just the starting date just hasn't occurred yet. And there may be reasons why, in turning to this case, why the trigger date will be left indefinite, as in, not a specific date, but based on a certain event.
I think, in answer to your question, I think it helps to look at subsection B, which is one of the things that 1-2Z tells us to do, is to consider the language in the context or with relation to the other statutes. So what section B does, it has a definite date. It's the date you sign it. It starts. There's no other option under that particular section. I agree that the section C creates better flexibility. Here's what the problem is with the statute. Just to do an analogy, if I handed you a tape measure and said, please measure 120 inches, you'd say to me, from what?
And if you told me, if you answered that question, then there would be no problem. And the contract does answer that question.
No, it doesn't.
It says from what?
Let me go to that, because I think that is the real problem, is the from what problem.
Okay.
And the language, just so everybody understands, comes from a prior contract that Jeanette had entered into. Is boilerplate transferred from another agreement. And it doesn't say, or at least counsel didn't characterize it accurately. So in the first part of paragraph 6, it says, shall begin at the time the developer becomes owner, option holder, designator. 3 different things can trigger the start of this statute. Query, what do you mean by owner? When the purchase and sale agreement was signed and they had an enforceable purchase agreement, do they become the owner? Is it the date the title transfers? Utterly unclear as to what makes you an owner, at least under this contract.
Let me ask you, I mean, I'm concerned about the implications of what your position is. If you had a real estate development contract and it was an agreement such as this, and the triggering date was identified as this begins at the time of the first issuance of a certificate of occupancy for the first unit.
Right.
Would that be okay?
I agree. I think it's a single date that can be determined.
It's a triggering event in the future.
Yeah, absolutely. I had no
So
problem with that.
What's wrong with having a unknown but definite triggering event?
I don't have a dispute about that. I think we agree on that. If the contract is clear as to, it can be determined as to when the start date is, that's fine. This contract has 4 different start dates. It has the 3 that I just mentioned, plus it has language that says.
Doesn't it start at the first triggering event?
Because if you read the language, it isn't clear which of those events starts the contract. So if multiples of those happen, which happened with Abbey Woods, Do you start a new 10-year period over again? That's one of the problems
That's
with the
not the
language.
case though, is it?
Yeah, it is. Abbey Woods, if you take the point that they became the owner, that starts a 10-year period, either in 2003 or 2005. They lease a unit in 2013. That starts a new 10-year period. The Abbey is the perfect example. The other perfect example is Windermere, for which this contract has never started. And so, and that was obviously Judge Prescott was remarking on that because one of the things you can't do in interpreting a contract, and understand that this, as the regulated community, it is the broker's obligation, because they are governed by these rules, to create a contract which meets the terms of the statute. If they don't do that, it's unenforceable, period.
The appellate court rely on the argument you're making right now?
Which one?
The one you just made, that
Windermere.
this doesn't work because there's 3 possible or 4
Yeah.
possible trigger dates.
Right.
And we don't know which one. I didn't
Well,
see it, but maybe you can point me to the, is this a different argument?
It incorporates their reference to Windermere as an example of an event in the future that cannot be determined and may never be determined, is the language that the appellate court uses, and then goes on to point to Windermere as an example of a future event that never occurred and may never occur, in which
It's
case.
not because the language of the appellate court, maybe you can come up with different arguments. I'm not saying that this is a ineligible argument, but
Okay.
I mean, maybe it is, maybe it isn't, but that's not what the appellate court says, and it doesn't depend on the Windermere property as an example of the uncertainty in the language. It just says, hey, that may never get sold.
I'm sorry, I read it differently. I thought that's
Okay.
what Judge Prescott was doing, was using it as an example of the general point that these things may not be knowable. And he was deriving that from the language. And it's helpful to have him, the statements by the court, the appellate court at 326 and 327, is it's unclear how far into the future the parties would be bound. The amount of time the parties were bound by the agreement was indeterminate, because it could be calculated only by reference to an uncertain future event. And that's when he went into the Windermere. So the court speaks generally about that problem, but they're talking about the language of paragraph 6, which is what causes the uncertainty. You have multiple different start dates that could commence. And, for example, what is a designator? I looked that up in Black's. They don't have a definition of what a designator is, and I don't know when it starts if you're a designator. So the problem with the language was introduced, as the trial court found, by Ted Haddad Jr. He's the cause of the uncertainty. He was the draftsman by bringing this copy from the prior agreement. And he and his mother, who signs the agreement and is bound by it, is bound by the statute. And the statute requires a duration of authorization so that everybody can know when Jeanette Haddad has an exclusive arrangement that they can't interfere with. And the owner can understand when they can get rid of Jeanette Haddad if they're unhappy with her, or when another broker can come to them with a deal and say, hey, I've got a buyer for you. Are you free to deal on this? And everybody in that transaction has to be able to understand whether or not there is still an agreement in force.
On the right to third parties, just a quick question. Is there any law or legal requirement that the listing agreements be public?
There are no law requiring that, but they are commonly posted on the multi-listing service. Brokers cooperate with information about.
They don't need to be on the land records.
No,
or
they don't.
Otherwise made available.
Not so far as I'm aware, Your Honor.
Thank
you. So I think one of the things that courts commonly say about these kinds of transactions is, in interpreting a statute or a contract, is the interpretation should not yield absurd results. And if you adopt the arguments that are being made by the plaintiffs here, these are 3, I submit, absurd results that occur. So with Windermere, they still contend they have a contract with Windermere to option to sell this property 20 years later. 20 years later, it's still under contract. There has been no transaction whatsoever. No ready, willing buyer has been presented by anybody for this property. Yet they contend that this is still.
Is there something magical about that though? I mean, the parties here, the relationship soured,
Right.
but you could easily imagine where the relationship's not sour and 20 years wouldn't be. Is there something about 20 years that makes it special? If the relationship was a great relationship and they wanted to continue it indefinitely, 20 years would be a blip on the radar screen. So why 20
Because
years?
that's the antithesis of what they agreed to, which was 10 years. You can't convert 10 years into an indefinite period.
they
We're
agreed-
at 20 and still counting.
They agreed to 20 years from a specific date that just hasn't occurred yet. So when that sale occurs, it'll be 10 years from that date.
Well, that leads to the second absurdity in this. So the broker's obligation to sell the property does not begin, they don't have to do anything until the term begins. Up until then, they can sit at their desk and do nothing. Their theory on Windermere is it begins when there's a deal for Windermere. So until there's a deal for Windermere, they have to do nothing because the contract hasn't started, and then it continues for 10 years after there's a deal for Windermere. It's a structure you can't make sense out of, and it leads to absurd results. The other absurd result is Abbey Woods, which you have a situation where there's a transfer of the property initially in 2005, and then there's a second event that arguably starts a second 10-year period while the first one still has not expired. And that's contrary to the statute that I did cite against these evergreen contracts. And I dispute with counsel that that's intended for residential purposes alone. It doesn't say that. There is an antithesis in the statutes to automatically renewing these contracts so they become evergreens, which I think is the situation you're envisioning, Justice Mullen. So I think that the appellate court certainly did its job in interpreting the statute. I think its findings that these are unclear in terms of the dates is supported in the record, and I have no indication from counsel that it's clearly erroneous, which is, I think, what they have to demonstrate, that the conclusions about the ambiguity are simply wrong. I think it is ambiguous, and the burden is on the party that is governed by the statute, which is the brokers, to get it right. And they didn't get it right, and they were controlling the writing process at the time. There was a back and forth prior to this meeting, but at that meeting, it was their way or the highway. And so they take the risk when they shove something under somebody's nose and say, this is what you got to sign.
Is that true when both parties are sophisticated commercial actors?
Yeah, that case law I submit does not apply here for two reasons. So if you go back to the source of it, which is Talmadge Brothers, that's absent a clear public policy to the contrary is what the courts usually start with. In the absence of a clear public policy to the contrary, you should have freedom to contract. There is a public policy. It's statute 20-325, and it's the public policy that gets enforced here, despite the ordinary rule of freedom to contract.
And under that statute, who is the party that is, why is it the owner that is being the protected individual? I mean, I don't understand. I get it if you're talking about a small party, but this is, your client is a very sophisticated actor in the commercial development space, right?
The answer is that if you look at the history of the statute as a whole, and then start to read the language, the only parties that are addressed by the statute are brokers, period. Brokers and their agents and their agencies. There is no mention of owners of any kind residential, commercial, whatever, sophisticated or not. This,
Doesn't it stand to reason that the statute is there to protect owners who are not sophisticated in the ways of real estate?
I agree.
So, I mean, your client does nothing other than develop and manage real estate.
Correct.
So why do they need to be protected by the statute?
Because the statute isn't addressing owners at all. It's addressing brokers. The focus is on controlling brokers in a way that brokers do not engage in activity that is detrimental to the market, to the real estate business world. And they have proved to be an elusive group. There's lots of statutes and lots of regulations, lots of education that goes on, and lots of case law that this court deals in with brokers who have stepped over the line. And so the focus of the legislature is solely on the brokers. The beneficiaries are owners, but the legislature hasn't distinguished that they'd like residential people to benefit more than commercial people. So there's no indication that my clients deserve any less protection than, mom and pop are out buying their first house.
But we have said that in commercial transactions, there's a little more flexibility to the writing.
The statute is clear that the form of the writing is not as rigid as in residential transactions. So in a residential transaction, you got to start on the date you signed the agreement, period. No exception. If you're going to comply, that's what you have to do. If clearly commercial, the flexibility is, well, you can pick the date that the agreement starts, or pick an event that's going to start the contract period. You have that flexibility because presumably in commercial dealings, that's a desirable thing. It doesn't excuse you from coming up with some language that you can't tell when it starts or when it ends. And that's the problem with this, is we don't know from what we're measuring it, because it's multiple things and we're not clear on what those things are or when they occur. And that's the problem. It isn't the flexibility that was given to commercial people. It's that this particular agreement just does not do the job of being specific about when the contract starts and ends. And by the way, this is standard contract law, which is that the courts disfavor agreements that are indefinite in time. And the courts will, in common cases, impose a reasonable time, which is what happens in Harris versus McPherson. So the common law would object to this agreement just as much as the statute does itself. So I think that the statute aligns with the common law that has been developed by this court on contracts generally and real estate contracts in particular. I would like to spend a few minutes on the second issue if I could. That issue, I think, was clearly determined by the trial court. There are extensive findings of fact on pages 37 through 42 of the clerk's appendix, dozens of exhibits, testimony. On page 44 of the court's decision, the court says as follows: the court finds that the parties intended that the broker recognized in the listing agreement to provide brokerage services was Jeanette Haddad personally, and that the agreements and performance obligations were non-transferable. That's the finding of the court. It's supported by the sub-findings that are made all throughout the opinion.
So she personally signed it.
Yeah.
Does that mean that the efforts made under that can't be made by her agents?
No, that's not our contention. And that's an issue of performance of the
Right.
contract as
Right.
opposed to the making of the contract. But the court did address that because counsel raised at a trial that somehow this performance by the son, because she had some health issues, had somehow created a substitution by him for her. The trial court dealt with that and found that there was no substitution.
Well, why would it have to be a substitution? It can just be, look, you hired me and I had my assistant doing the work.
Right.
And I wasn't in breach, therefore I wasn't in breach. It's not that the
Right.
assistant was substituted.
Right. I think, I mean, to make a common analogy, if a solo lawyer has a paralegal who, does a lot of the work on a real estate transaction, you hired the lawyer, not the paralegal. The individual can delegate.
Well, what if a
some of the
lawyer has an
responsibility.
associate, a partner has an associate, just to change your hypo
Sure.
a little bit, right? You hire the, say, partner, whatever, it's just, a law firm of, and I don't know. It's everybody knew she wasn't doing the legwork.
Well, no, I dispute that. What she brings is 40 years of contacts within the industry, respect within the community. She has the ability to pick up the phone. This is not a property where you're showing up with John and Mary Doe and saying, let me show you the house. This is an undeveloped property that people just drive through. The way commercial transactions are done is advertising, picking up the phone, calling your contacts list, saying, I've got a property here. She can do all those things.
I thought the trial court found that there had not been a breach, that there had been efforts made, or am I wrong?
There were some efforts made through 2007. The court notes that after 2007, and it has various reasons that it happened, some are market-based, nothing happened by anybody.
But why isn't this more a question of standing than of a personal services contract? It was a deal with her agents could help.
Right.
Maybe she did some of the work. The question is who gets to sue for breach.
Right. And the answer is, and the trial court was clear on this, if it's a breach that occurred when she was alive, then the estate has the right to bring that claim on her behalf. But what they're claiming is leases that occurred a couple months after she died. And at that point, by effect of law, she's unable to perform. The second thing to keep an eye on, she's a licensed broker. When she dies, her license disappears. And
so there's no claim here for any commissions earned before her death?
Right. And I've been in the case since the beginning 8 years ago, and there never has been a claim that she did something during the time she was alive to earn a fee.
Is there any claim that your clients did anything during the time to entitle her to a fee? You know what I mean?
I follow that. There's no allegation that, for example, our clients did, secret negotiations with somebody and cut a deal on the side, or, the law is really clear on this ready, willing, and able language. And there are countless cases. He cited the Goldblatt case. That's a good one. New England Retail Properties, Smith versus Caldwell Banker. They all say the same thing. A commission is earned when a broker, any broker, if it's exclusive, it's any broker, produces a buyer ready, willing, and able to take the property on the seller's terms. So if the broker does that, they earn a commission. It's a condition precedent, and it's in the law. It's embedded in decades and decades of this court's law.
So is your point on this, on the personal services, and if you'll pardon the fact that I don't know this regulated industry as well as I will, is the point that she could delegate? Sure. She may have delegated to brokers. They might have been the listed broker on they could have been, they were eligible to be the listed broker on a deal. They weren't for this deal.
Correct.
That's your point?
That's exactly.
So they're really no more than, I'd call them agents or employees or what have you.
Exactly.
Okay.
Yeah, she's a sole proprietorship. Her husband, just so you understand, her husband was not a broker. He was an agent, and an agent can only work with a broker.
But the son was?
Son are independently a broker with his own agency, and it's very clear that my clients had no dealings and no desire to deal with them on this, and the court found that was unequivocal. And the finding by the court at page 44 of the clerk's appendix is the following. The defendant's acceptance or acknowledgement of actions on behalf of Jeanette does not mean that the defendant substituted Ted Haddad Jr. and Sr. for Jeanette. And the law is very clear. We don't infer a substitution. That's under Rossetti. The general rule for personal services is that they can't be assigned. and performance cannot be delegated, complete performance. And Connecticut General Statute 20-325 prohibits sub-agencies, which is what that would be if Ted took over for his mother. That's a complete substitution. That requires written consent of my clients, which of course they never gave and would never give. So I think on all counts, the second issue resolves just as the trial court found it. Thank you.
Thank you, Counsel.
Working backwards, we never argued to the trial court that Ted Jr. was substituted for his mother, as if he kind of morphed into the principal. That was not the claim. The claim was, under Rossetti, was personal performance of Jeanette herself of the essence of the agreement. The undisputed facts, which the appellees make no attempt to dispute in their brief, is that the Keeners knew from years of dealing with the Haddad family that Jeanette used her husband and her son regularly in performing her duties, including duties for the Keeners in prior contracts. The facts are that Ted Jr. actively negotiated the contract on behalf of his mother. The facts are that Jeanette, although she was hobbled by illness and had to rely on her son and husband, did participate actively, but at no time after the agreements were signed did any of the Keeners say, hey, we don't want Ted Haddad Jr. coming to a meeting. We don't want Ted Haddad Jr. preparing prospect lists. They knew.
But is that the question, or is the question, who is the broker? Who is the exclusive broker? And you're saying that it could be all of them.
I'm saying that as the broker, did she have the right to employ agents in the discharge of her duties?
I mean, this is maybe somewhat of a just an industry question, and I rely on your expertise for it. Wouldn't the usual way be to sign the contract as the company, so that you know that, and everybody knows that it survives? No?
I don't think so, Your Honor. If you look at the statute, it says any broker may sign an agreement, and including brokerage firm. It's not mutually exclusive. And again, Jeanette Haddad had been the signing broker on all the Keener contracts before this. They never objected. And on the question of personal performance, the Keeners over and over again said, we didn't want to use Jeanette Haddad because she didn't have the national expertise to deal with these properties on a national footprint. Under the restatement, if it's impracticable for the agent to perform the duties herself, that shows that she may properly delegate it. They knew, the defendants knew that she was not herself capable of doing it, acquiesced in her husband's and son's activities over all the years, never once objected, and that's a waiver. Even it's a waiver. Very quickly, under Rossetti, the personal performance was not of the essence. The facts are undisputed on that. 2325F, I'll rely on my brief on it. It clearly does not apply here. It's a sub-agency statute, has no relationship to this case. What we have been talking about.
Does the clearly erroneous standard apply to this, the trial court's findings with respect to the personal services?
My argument is no, because the facts are undisputed and therefore it becomes a question of law. We've been talking about strict compliance with subsection C. We have not talked yet about the substantial compliance issue under subsection D. Location Realty versus Colosino says, if you're going to apply subsection C, there's got to be substantial compliance. In other words, there has to be at least some effort to put something in writing. There has to be a writing to some extent. In that case, they said, well, subsection D is not complied with because there was no writing whatsoever. Here, what do we have? 14 drafts of this agreement back and forth in the weeks before the meeting. The agreement, the sets of agreements are detailed. They comply with all of the statutory requirements except arguably the duration required. How is that not substantial compliance under this court's ruling in Location Realty. As to the policy issue, the question from the court was, well, wouldn't other brokers be acting at their peril because they wouldn't know that there was an exclusive right to sell agreement? 2 points. One, Regulation 20-328.3, which was cited in the Rells case of this court, said any broker who knows that there's an exclusive right to sell listing agreement in place between the owner acts illegally by entering an agreement with the owner. More importantly, the NRT case, the appellate court case, says if you're the owner and you're an exclusive right to sell agreement, you can't just ignore it. You can't just go out and hire somebody else and have them do the work and then claim after work, well, that broker didn't do the work. You act at your peril. So this notion that it creates chaos and uncertainty in the brokerage world or the owner's world is simply not supported by NRT or the regulations. The issue of open-endedness as the parcel 15. Yes, there hasn't been a